Hey guys, Tammy here, and this week we're going to talk about 5 types of court hearings in child custody. Frequently when I talk to a new client and they start asking questions, and one of my questions frequently for them is, well, what kind of hearing are you set for? And the answer is frequently, I don't know. Well, I don't know leads to a lot of stress and anxiety for you because you have no idea what to expect. So, I'm going to give you 5 of the most common ones. Every jurisdiction is different. This is not an all-inclusive comprehensive list. Every jurisdiction does it a little bit differently, but these are kind of 5 of the most common. If you like my content, let me just remind you to hit like on this video. And also, if you have not yet subscribed to the channel, please do that if you're watching me on YouTube. 5 types of court hearings in child custody. I think that, the one that comes up most frequently, and in California in particular, they set this one pretty regularly when you have an ongoing case, okay? That you don't have these as much for like post judgment motions. If you're in the middle of divorce case or this is your initial parenting case or whatever, you will usually have what we call status conferences. Um, and other jurisdictions use status conferences as well. And what status conferences are typically is just to go in front of the judge, and it's a procedural meeting. So people tend to think, oh my goodness, am I going to get this order or that order at the hearing? Or people will ask, well, will my divorce be finalized? I get that question a lot at the status conference. And status conferences are not for judges to make orders. They are for just like to see, like I said, procedurally, where are we at? Like, do we think we're going to reach agreement? Is there still discovery that needs to be done? Do we need to set the case for trial? Do we need to set the case for, a mediation? Like, what is the status to get this case moved through the system? Okay, that's what a status conference is about, is like, what are the things that are left undone to be able to move this case through the system? Now, there's another type of conference that's frequently used that's called a pre-trial conference. And this is what we see either one, if your case for divorce or parenting is set for trial, or a lot of times in a post judgment motion where things are set for trial. And if you don't know what a post judgment motion is, I just mean like after your initial case is done, if you come back for a modification, that's usually referred to as like a post judgment motion. So a pre-trial conference is it can be more involved. I think that those kind of vary more depending on the judge, but typically same thing. We're trying to see, are we ready for trial? Like, is there more discovery that needs to be done? Is there more, investigation, whatever that one side or the other needs to do before we can be set for trial? So again, they're trying to take sort of the temperature of the case to figure out if we're ready, if all the procedural stuff is done so that we can actually set the trial date. Status conferences, the first one I talked about, if you have an attorney, a lot of times only the attorneys are present for those. A lot of times the client isn't. But a pre-trial conference, typically you will have the client there also, just in case, depending on how involved the questions and all those things are. The next thing that I see sometimes is, especially when somebody files their initial filing, they'll have something that's called something along the lines of a custody. Some places call it conciliation. It's sort of like an attempt at mediating the custody issues, right? At like settling them. And in California, we essentially do that through family court services, is what it's called here. But a lot of places do refer to it as conciliation, or they'll say, oh, custody mediation is required before you do anything else. And so those types of conferences are really settlement negotiations. Essentially, you're trying to resolve your custody issue through a negotiation process instead of leaving it in the judge's hands to make the decision because you don't agree. So let's talk about the third type of hearing, and this is a motion hearing. Now, my late husband, Thomas, who was an attorney, You probably heard me talk about him before on the channel if you've been listening to me for very long. He used to call the motion hearing the workhorse of the family court, because essentially what a motion hearing is for is anytime that you have a disagreement with the other parent on what to do on any issue, you set a motion hearing. Okay. So that can be custody. Maybe you're not agreeing on a parenting plan, or you're not agreeing on, support, or you're not agreeing on, extracurriculars, or if the child should be in therapy, or whatever the issue is. Those issues are typically heard at a motion hearing. In California, we call it a request for order hearing. Um, some states call it an order to show cause hearing. We used to call it an order to show cause here in California, but they changed it, I don't know, 10 years ago or so to request for order. I don't really know why. But those are all motion hearings. So, motion hearing is meant to be kind of a shorter hearing. I think here they're capped at like 40 minutes, and I think that's pretty typical, 20 to 40 minutes. And they're not meant to be anything beyond that time length. Anything beyond that time length is usually then set for what we call an evidentiary hearing, which I'll talk about next. But these hearings typically are not for taking live testimony. Okay, that's kind of the big difference with a motion hearing versus an evidentiary hearing or a trial, is that motion hearings, there is not typically live testimony. For the vast majority of the information in a motion hearing, we do it via a written declaration from the parties. Okay, so some places, again, call that affidavit. It's called different things. But that written affidavit or declaration is how the information gets into the court, as opposed to it being oral testimony. But if you're self-represented, one of the things I would really caution you about is being aware of the time restriction. Because when we're saying a motion hearing can't be over, 30, 40 minutes or whatever, but you think about it logically that a court judge would have 10 to 15 hearings on for a morning calendar, which is at best, 3 hours most of the time, maybe 3.5 if everything is stretched, but most of the time it's right around 3 hours. So when you're talking about getting, 15 cases into 3 hours, well, that's an average of less than 15 minutes per case. So even though the maximum allotment is that 30, 40 minutes, obviously every single case can't take that long, or they won't get through the calendar. So they are very time conscious when they're going through these. And if you are self-represented, one of the things that you have to be very cognizant of is that the court is on this time crunch, and you have to be able to provide them the information they need in a very succinct, organized manner. Most of the time when I see self-represented parties get cut off, it's because they start at the very beginning. Well, I was born on a cold winter's day in 19, type of thing. And it's like, no, you can't go there. You don't have time for that. Okay, you've got to give your high points. And this is why you do the written declaration or affidavit in the first instance, so that you can lay out all that detail for the judge. And hopefully your judge has read that. They should have. I have seen ones where they're not great at doing that. But for the most part, the judges read that and should already have that information. So you don't want to regurgitate your declaration. It's simply a matter of you understanding the procedure and the etiquette that's involved around that procedure. So let's move on to something that I touched on that I was talking about, which is evidentiary hearings. So if you have a motion hearing and the court goes, well, there's not enough time, I think we need to take testimony, we're going to set you for an evidentiary hearing. Or if one of the attorneys says, Your Honor, I think I need an evidentiary hearing to effectively present my client's case. Or if a self-represented party asks the court for that. There's different rules in different states. So, I have clients that get really frustrated and go, well, why are we now set for trial? Which is essentially what an evidentiary hearing is. An evidentiary hearing is essentially a mini trial, right? Trial is generally thought of in like half day, full day type of blocks. And trial is generally considered to be like the whole case, right? The whole kit and caboodle. Evidentiary hearings are sometimes either shorter windows, like a 2-hour window or something like that, or sometimes they will be just on one particular aspect of a case, one particular topic. So, evidentiary hearing and trial are essentially procedurally kind of the same thing by a different name. It's just sort of a matter of like how long it is, how many issues they're covering, all these different kinds of considerations. But essentially, at an evidentiary hearing or a trial, you are putting the parties on the stand and the evidence to the court becomes that testimony. So, in the motion hearing, how we're writing things out, we're not doing that at trial. We are giving the information through the testimony of each party. Try not to get super frustrated with your judges. Try to figure out, like, okay, well, why was that done that way? What are the rules around this in my state? I always tell people a great resource is your law library. A lot of people don't even know those exist. I don't know that I really knew they existed before I started working in this, but there are here in California, there are libraries at essentially, at least in San Diego, there's one at each courthouse. Near each courthouse, there is a law library. So you can go in there. They have all the code sections, in books. They have all kinds of different resources. They have the ability to go onto the computer and search different legal databases. There's all kinds of great information and learning that you can do in your local law library. You might know your case. You might know what's happening with your kids, what's going well, what's not going well, how the communication with the other parents going, all that kind of like internal working or the problems that need to be resolved. But you may have no understanding of the system procedurally. You end up frustrated, you end up emotional, you end up reactive in court because you feel like people are or judge is ruling against you when in fact judges maybe in some instances doing the only thing that they can do, procedurally under the laws in your state. So it's important to educate yourself and do these things. I tell people, like, if you can't afford an attorney, a lot of times it's still helpful to buy an hour of their time and have somebody that you have the ability to consult with. There are people that do that. Not every law firm or solo attorney will do that, but a lot of them will, where you just say, look, I want to use you as a consultant and I want to be able to come in and ask questions and help me understand what's happening and how do I prepare and, all those kinds of questions that procedurally we don't know the answer to. Okay. I have clients do that locally a lot. A lot of my coaching clients, I say to them, look, okay, you're going to try to self represent and you want some coaching to help you, do this well and behave well and navigate well. But, let's find a local attorney that you can consult with to help give you legal advice and to be able to help you navigate the procedural aspects of this process. So, just trying to learn to use all these sources in combination, especially if you are in a position where either you can't afford full-blown representation or frankly you just haven't had great results from it and you really just don't want to pour more money down that hole. That's the case for a lot of my clients as well. If you'd like to get more help on understanding these types of things, you can go to Divorce University Online divorceuniversityonline.com. That's an important piece, right? /VIP coaching. There's information on that page on my coaching services. And I believe there's also a link on that page where you can book a call with me if you'd like to learn about my one-on-one premium coaching services. Thanks for joining me, and I will see you guys next time.